on the scales of private law. Nano Contracts, appearing in the Harvard Journal of Law and Technology, 2024, by Yonathan Arbel, narrated by the late Richard Feynman, who inspired this article and to whom it is devoted using AI voice cloning. Abstract contracts are falling in scale. When I say new contracting trends and technologies facilitate the formation of smaller scale contracts that have extremely short duration, stakes, and scope. These nano contracts embody ephemeral interactions of minuscule value interactions that were so far outside the law and away from explicit markets governed only by social norms. The rise of nano contracts can unlock new transaction types, opportunities to build wealth, and reduce dependence on private ownership. Yet they also carry important risks, and their small scale makes them difficult to effectively regulate. At the limit, nano contracts collapse private law boundaries between property, torts, and contract, and would require a rethinking of the basic private law category. This article offers the first comprehensive study of these Lilliputian agreements, examining their potential while attending to questions of enforceability, market creep, and disparate impact. The analysis reveals the essential, if neglected, role of scale in private law and how it can and should inform jurisprudence and policy. Part 1. An introduction. There's plenty of room at the bottom. In the 1959 annual meeting of the American Physical Society, theoretical physicist Richard Feynman stood up and took the stage, set to deliver a puzzlingly titled after-dinner speech. With his signature, mischievous grin, Feynman sought to persuade a room of physicists that they should turn their gaze from the heavens above to the molecular level below. It is at the bottom, the smaller scale of atomic interactions, that we can find grand opportunities for innovation. In his inimitable style, he invited the room to imagine what it would be like to swallow the surgeon, to be able to replace the heavy hand of the surgeon with a pill containing a nano-robot that performs operations with perfect precision. Miniaturization and development of nanoscale technologies could lead to grand discoveries, or so Feynman claimed. But the room wasn't quite ready for this message. His ideas were summarily dismissed as fanciful and outlandish. Time, however, stood on Feynman's side. The nanotechnology revolution was built on Feynman's ideas and exhortations. Today, nanotechnology is growing everywhere, from medicine to engineering and from manufacturing to science, attesting to Feynman's prescience. There is plenty of room at the bottom for contracts, too. This article's overarching argument is that, 1, current technological trends show a dramatic miniaturization of contract scale, and 2, that the changed scale has deep legal implications. What I will strive to show throughout is that scale transformations do more than change the commercial aspect of transactions. They also carry the seed of social transformation. Drawing on examples of past scale transformations in contracts, it will become clear that a falling contract scale can lead to broad social, political, and material changes. But while the march of technology is likely inevitable, the social response is not. Some of the changes carry great promise, promoting greater autonomy, choice, and prosperity. Yet, if the legal response is inattentive, these changes can also imperil social values, marginalized communities, and freedom. The article works to illuminate both the promise and peril that lie at the bottom of contracts. To motivate the analysis, consider the joint effect of some recent collinear trends in contracting practices: digitization of the contractual forms, cultural normalization of digital deals, the dispensation with wet signatures, the thundering rise of everything as a service, contracts, the tokenization and fractionalization of ownership, the ascendance of high-frequency trading, itself often a form of nano-contracting, the increasing ability of artificial. What ties these trends together is their creation of infrastructure that allows for the formation of agreements at near low latency and at asymptotically low transaction costs. These trends set the ground for a new breed of contract. Nano contracts. Nano contracts are digitally negotiated agreements that employ automated and near instantaneous bargaining processes in multi-party peer-to-peer transactions. What makes them nano is their scale. They cover transactions that last a few seconds, transfer cents, mills, and even smaller fractions of the dollar, or transfer slivers and fragments of the bundle of rights of ownership. Their P2P character reduces the need for intermediation, and thus allows parties to transact with each other without necessarily involving firms or platforms in the middle. Two preliminary questions immediately present themselves. Is there anything truly new about these agreements if they are simply smaller scale contracts? And are these fleeting agreements even properly called contracts? On reflection, these two questions respond to each other. Classical concepts of definite position and momentum break down at the quantum scale, so do contracts. In classical contracts, the most basic distinction is between pure exchange relationships and contractual ones. This classification is made based on certain assumptions about the identity of the parties, their capacity, the negotiation process, the values exchanged, and so on. Because these assumptions no longer necessarily hold, it is increasingly difficult to classify nano contracts as either contracts or spot exchange. The blurring of these two categories is what makes nano contracts so interesting to study. This point is best illustrated through a recent example. The rise of the gig economy brought its own scale transformation. Before the gig economy, short transportation agreements were mediated by the state through licensing and certification schemes. Uber and Lyft changed that by arguably disintermediating the relationship. Much of the recent warfare around these platforms is about the classification of the agreements they facilitate. Is an employer, what does it owe its drivers? Uber proposed that it only matches passengers to independent contractors for pay, and that this exchange does not amount to a contract, hoping to skirt the responsibilities of an employer. Drivers might like to emphasize a more contractual relationship between them and the platforms for precisely the opposite reasons. The new technological form blurred traditional boundaries, resulting in novel and socially important questions about the scope of contract. Such legal encounters teach the general lesson that in law scale has a quality of its own. Yet, as noted by Feynman, scholars and policymakers have overlooked scale's role in creating powerful new and sometimes fraught legal configurations. Nano contracts will bring their own questions about legal classification. Are nano agreements that let a party use another's driveway for a brief stop, for example, best understood as leases, licenses, or something else? Should ephemeral agreements to sell one's right-of-way be enforced as contracts? The small scale of nano contracts brings with it new questions which we have not yet considered, making our regulatory framework quite fragile to these developments. The final preliminary question is how nano contracts might differ from other forms of digital contracts. The answer, which admittedly sounds like it comes from a college application, is focus and ambition. Unlike smart contracts, which are primarily tools of contract governance, the focus and ambition of nano contracts is to solve the problem of contract formation. It is frustratingly difficult to create systems that allow for the creation of very small transactions, because even small frictions can overwhelm the value of truly small agreements. Nano contracts address these issues using P2P digital protocols. Another possible distinction is that nano contracting technology does not require the blockchain or cryptography, although it could incorporate them if desired. This marks nano contracts as a discrete form of transactional technology aimed at addressing the negotiation and formation bottleneck. Nano contracts contain within them the germ of profound social and economic change. This germ, however, needs to be scrutinized before it spreads. A common saying in startup culture is move fast and break things. This article is interested not only in asking what will break, but also whose things are likely to break. Disruptive technologies, in a process of Schumpeterian creative destruction, often upend social and economic structures. Nano contracts disrupt a large domain of common interactions that, due to their minuscule size and stakes, were left outside the market. Interactions such as waiting in the line at the deli are today mostly governed by social norms. Nano contracts will allow parties to turn these interactions into transactions. To market enthusiasts, this presents an opportunity to open new markets and create new forms of wealth. To market skeptics, nano-contracting is yet another instance of market creep, which would inevitably lead to excessive commodification, economic exploitation, and material disparity. After the gig and sharing economy revolution, the import of these questions is timely and salient. Uber, Airbnb, TaskRabbit, and other sharing economy platforms created newfound sources of wealth for some people on the margins of society. But many other workers experienced financial losses and unemployment. Neighborhoods saw property prices rise and hotels faced a shrinking market. This type of analysis requires consideration of future trends and concrete use cases. To weigh these considerations, this article offers a variety of examples from diverse domains, some already deployed, others fast approaching, and yet others more imaginative. The nature of such projections is inherently uncertain, and so a certain degree of suspension of disbelief around the particulars is warranted. Niels Bohr was, after all, right. It is hard to make predictions, especially about the future. This article is about scale, contracts, and technology. Technology. It naturally engages with conversations around the gig economy, platform regulation, and more generally, consumerism and technology. It poses some timely questions surrounding the equitable distribution of the fruits of innovation. It also presses us to think carefully about the proper limits of markets in goods that, until now, have been unalienable due to the costs of negotiation. The article opens with a motivating thought experiment in part 2. Part 3 lays the foundations of nano contracts where they fit along contracts history, what needs to be true for them to work, and what we can learn about their organization from their constraint. From this trunk, 4 limbs branch out. One explores the implications of nano contracts on queues and the allocation of scarce resources. The other 3 explore the interaction between nano contracts and property, employment, and accident. Part 8 concludes with some short reflections. Part 2, a pedestrian thought experiment, nano contracts and the 4-way stop. To begin, let us consider a potential use case for nano contracts. Our opening thought experiment will be helpful in illuminating the potential and also the dangers and risks of nano contracts. It comes from a routine, almost invisible interaction that takes place with great regularity, the 4-way stop. 4 cars approach an intersection. The laws of physics prevent all cars from occupying the intersection at the same time. As they slow down, we witness the emergence of a valuable but rivalrous right, the right of way. How should society allocate this scarce resource? Admittedly, this is an odd-sounding question. We do not normally think of intersections and driving as problems of allocating scarce rights, but rather of obedience to the laws of traffic. Still, at a fundamental level, much of what traffic laws do is coordinate and allocate movement rights. And we want traffic laws do that job well. Now, ideally, scarce rights should be allocated to those who need or value them the most. But traffic laws adopt a mechanistic allocation rule. First in, first out, FIFO. A blind allocation of resources based on chance may fit some social settings, but this allocation loses luster when applied to actual road design. As a system, this distribution ignores many relevant moral facts such as need, urgency, or desert. Indeed, we encounter a common frustration every time we idle at an empty stop sign. Realizing all of this, various actors have made tweaks around the edges. Urban designers tried to adjust traffic light timing such that the odds of finding a green light will favor those on the more occupied road. Legislators set rules such that when a real emergency erupts, ambulances and the police can usurp the right of way. And in some parts of the country, the rule is further tweaked by social norms of courtesy, although those are not uniformly observed. Still, none of these tweaks do much to remedy the basic issue. Antecedence is not an efficient or desirable method of allocating resources. The problem is that it is hard to come up with a better system that increases fairness or efficiency. We have all been in situations where we were either late to an important appointment and needed some priority, or early with extra time to give. Most of us would see the utility, if not outright sanity, of a system where we could get priority when in a rush and give priority when time is on our side. After all, to give our place in traffic to the car carrying a person in the throes of labor is a matter of basic decency. But such a system is unworkable at scale. It is impossible to individually check each driver's level of urgency. Even if it were possible to inquire, why trust the answer? Nobody likes to sit in traffic while yours went by. Nano contracts offer a solution to this age-old problem. A nano contract application installed on every driver's car, phone, or autonomous driving system could allocate the right-of-way through automated bargains. Before beginning their journey, drivers enter their destination and their level of urgency, allowing the app to determine how much they value priority. As drivers approach an intersection, a silent auction is held, with drivers bidding in increments of pennies or in tokens for the right to pass through the intersection. The driver who wins the auction receives the right-of-way, and the apps seamlessly exchange payments between them in the background. These negotiations are near instantaneous and contain vanishingly low transaction costs. This process then repeats for those who come later, as they automatically negotiate their place in line, receiving and sending nano payments as needed. For example, Brandon, who left late to his meeting with a wedding photographer but paid his way to arrive on time, is now $3.10 poorer but much happier. Nicole, who had a relaxing afternoon ahead of her, leisurely parks her car at her friend's house after collecting $4.20 in fees along the way. She brings them both a cup of coffee. Before addressing any issues, let us first stop and appreciate the achievement of this system. These Lilliputian agreements offer a robust solution to a vexing problem. As a system, Nano Contracts ensure that drivers' needs, rather than chance or order of arrival, allocate the right-of-way. Close analysis will show that the system is also fairer than the status quo and offers people a greater degree of control over their lives. And because the system can run on priority tokens rather than money, we can achieve all these efficiency gains while promoting equity and access. Relative to our static system today, nano contracts offer a fluid, dynamic traffic flows. Static flows. While the four-way stop may sound like a small isolated example, it is not. In the United States alone, there are approximately 411 billion car trips taken each day through a total of 330,000 traffic lights. If even a fraction of those trips were governed by nano contracts, the potential benefits would be enormous. Traffic is far less stressful if, instead of fighting to keep your place, you make a couple of bucks by letting people pass you. And traffic is far safer if, even when people find themselves in a rush, they have a safer alternative to speeding that also ensures they arrive on time. If we can minimize idling time because priority cars do not need to come to a full stop, we can also reduce fuel consumption and noxious emissions. This stylized example illustrates the potential that nano contracts can unlock. Hopefully, it also sparks a sense of curiosity. If nano contracts can solve these rote invisible inefficiencies, what other inefficiencies are currently hidden? What else can we solve with nano contracts? Our example is also structured to elicit ethical and legal concerns. Applied without care, the use of nano contracts can result in priority given to wealthier parties. Would nano contracting force poor drivers to treat every four-way intersection like an endless red light? Would they create a new source of income for some people, or simply commodify yet another area of life? And then what happens in the nano contract world to the social norm of giving a friendly wave and letting another person pass before you? The commercialization and commodification of previously market-free areas may have a corrosive effect on social norms. Or what happens if someone breaches their nano contract and lunges into a busy intersection. These issues are real, as are the potential benefits. The goal of the legal system is to anticipate these concerns and develop appropriate legal and regulatory frameworks to ensure that when nano contracts are deployed, they are implemented in a responsible and ethical manner. Part 3. Fundamentals of nano contracts. Platforms, protocols, and legal technology. How much room is there at the bottom, and can we even get there? This part discusses these two forms of skepticism. The skeptic's first reaction concerns the value of nano contracts. Nano contracts, the skeptic reasons, are unlike a new form of a leveraged buyout or some innovation in futures contracts. Those are the truly important, innovative transactions. Nano contracts are small potatoes by definition. Do they deserve much attention? Section 3 explains the skeptic's mistake. Blind to the role of scale and in contracts, the skeptic is not only unprepared for the future of contracts, but also for their past. Examining the history of contracts from the perspective of scale, this section demonstrates how every scale transformation was associated with profound and unpredictable social outcomes. Scale, we remind ourselves, has a quality of its own. The second part of the skeptic's query challenges the feasibility of nano contracts in real-life situations. With such small stakes, practical concerns loom large. Section 3b responds to this challenge. Here, platforms and protocols make their first appearance, and they are shown to solve these practical concerns. Platforms have great utility, but they also introduce market power. The alternative protocols, which can also facilitate transactions without such risks, although they are harder to develop and maintain. But limitations notwithstanding, these alternatives render nano contracts feasible. Scale and contract evolution. The future impact of smaller transaction scale is not easy to predict. Fortunately, it is easier to predict the past than the future. Let us consider, then, key points from contracts history as they bear on the question at hand. To be sure, the story of contracts past is not a simple one. These legal agreements reflect a complex web of social, political, and economic forces, each vying for influence. What helps us see through this tangled web is thinking about contracts along a much simpler dimension. Scale. As presently argued, over time the Anglo-American legal system has developed legal technology that supports transactions that are increasingly smaller and more flexible, allowing for more complex and varied interactions and social arrangements. This shift led to the paradoxical result that we see the simultaneous emergence of record-setting multi-billion transactions among firms and $5 contracts for gigs, among other fleeting engagements. Take the move from status to contract. Under the manorial system, people were bound by all-encompassing legal arrangements known as status. Status arrangements dictated nearly every aspect of the lives of the people living in the system and left little room for individual choices. These stringent social-legal arrangements defined an individual as a serf, villain, vassal, and later indentured servant or peon. These rigid structures of status were bound to crumble. As Henry Maine famously observed, the social pressures pent up, BTT movement of the progressive societies has hitherto been a movement from ESS status to EGC contract. Over time, the old forms of status were stripped down to shorter, more modular transactions that were terminable and, warts and all, voluntary. Contract technology then allowed people to enter new forms of transactions, including employment contracts, lease agreements, bailments, and warranties. None of these new forms of transactions emerged at a defined point in history. Rather, they represent a protracted and uneven process where smaller scale transaction types slowly gained judicial, social, and political recognition. The transition from large-scale status to the smaller units of contract has had a profound impact on society that continues to shape the way that people and businesses interact. It can be difficult for a modern reader to fully appreciate the significance of this shift. Fortunate Yonathan Arbel has provided us with a view from within of these transformations by examining the travails of one prominent individual who lived through them, Johann Sebastian Bach. As Arbel recounts, up until late in his adult life, Bach served as a status-determined servant within a feudal hierarchy. This status designation constricted Bach and could have deprived the world of one of its greatest composers. When Bach tried to leave Weimar, his seigneurial lord expressed his displeasure by having Bach incarcerated for almost a month. After many troubles, Bach was finally able to leave for Leipzig, where he became the celebrated musical director of the Thomasschule. There, Bach was able to put his status-laden legacy behind him and sign his first significant formal contract. It was then that Bach began to talk, contract. He may have in fact spoken contract too eloquently, as he soon found himself engaging in acrimonious negotiations and legal disputes with his new counterparties at the city council. Thus Bach's transition was not a singularly sanguine story of redemption and empowerment. His letters portray a record of grievances and disappointments by a person who was, to put it with utmost respect, a real nudnik. Still, even if Bach may not have always been thrilled with the new responsibilities and challenges of his contract position, he ultimately embraced the freedom and flexibility that it offered. Most importantly, he never went back. His experience is a synecdoche of a larger societal shift from status to contract, as millions of people around the world left feudal systems and entered a new era of economic and social interactions based on comparatively voluntary agreements. Today, every market-based economy in the world relies on contracts as a central tool of resource allocation. From employment contracts and leases to warranties and bailments, we see in all of those smaller-scale transactions how the shift from status to contract has irreversibly redefined business and individual interaction. Less than 2 decades ago, a different transformative innovation took place: the birth of the gig economy. Platforms like Uber, Fiverr, and Airbnb transformed the way we work, travel, and do business, enabling the creation of short, small-scale contracts. As the name alludes, at the heart of the gig revolution is scale, centered around the short and small scope of the engagement. And indeed, the gig economy downscaled contracts further and made them less lumpy in scope, duration, and stakes. Uber transformed hiring a personal driver into a single ride deal. Fiverr converted general contracting agreements into a 20-minute gig, and Airbnb reshaped private residence subleases into a one-night proposition. By comparison, these traditional plain vanilla contracts appear as macro contracts relative to the micro contract of gig engagement. To be sure, gigs were not a new concept when these companies first emerged, and the gig economy did not introduce any breathtaking doctrinal innovations. Rather, what is notable about the gig economy's impact is scale. The advent of internet infrastructure has made it possible for the first time to build large-scale marketplaces for small transactions, gigs, and other limited-term engagements. And just like the move from status to contract, we again see how smaller arrangements facilitated macro transformation. Critics of the gig economy argue that it undermines workers' rights, unfairly disrupts the character of neighborhoods, and leads to the exploitation of foreign and domestic workers. At the same time, the gig economy brought with it enormous benefits, enabling people to work on their own terms and earn a living in ways that were previously impossible. Between these two tensions, one conclusion is indisputable. The downscaling of transactions has had a profound effect on the lives of people around the globe. This short historical tour offers a clear response to the skeptic. Independently of any doctrinal or conceptual revolution, contract scale has always had a transformative effect on the transactional world. From status to contract and from contract to gig, nano contracts represent a general arc in the history of contracts. This history entails continuous downscaling of transactional blocks to profound social effect. Of course, for nano contracts to fulfill this potential, they must be workable. The next section moves to consider a systemic view of nano contracts from an engineering economic perspective, revealing in the process the role of legal structures Nano Contracts is a technology. Nano Contracts use digital infrastructure to facilitate the automated, real-time P2P bargaining processes between strangers. Such technology can wield different forms. For example, in the four-way stop example, a Nano Contract app conducted an auction to determine which driver gets the right of way. But this is just one bundle of features for the implementation of Nano Contracts. In some cases, Nano Contracts may use fixed prices rather than auctions, and in others they may facilitate exchanges based on barter, reputation, or even tokens. While Nano Contracts' flexibility allows them to fit many use cases, this feature also makes Nano Contracts difficult to define. Boundary setting is made more difficult because scale is not one-dimensional. Rather, scale covers transactional duration, transactional stakes, and the scope of right transacted, and there may even be some conflict between these dimensions. A contract for leasing goods for a few seconds may still fetch a high value, as we know from the pervasive high-frequency trading industry. These challenges notwithstanding, the examples provided in parts 4 to 7 will cement some idea of the core and periphery of this concept. Nano contracts arise from the natural continuation of the existing trends noted above, including the proliferation and normalization of digitized agreements, the growing digitization of goods and services, and the emergence of persistent connectivity at lower latency geolocated individuals and objects. These mutually reinforcing trends enable, technologically, legally, and culturally, the ability to form P2P contracts in real time at near zero latency and at vanishingly low transaction costs. While each of these trends is worthy of full treatment, I focus on one recent trend overlooked by contract scholars that lends special credibility to the emergence of nano contracts, the rise of the SaaS contracting model. In the days of yore, people bought products from sellers and services from service providers. So central was the distinction that it was deemed fitting to construct an entire body of law that deals with one rather than the other, and then test neophyte lawyers on it. In recent years, a new model transitioning erstwhile products into services has started taking over, commonly abbreviated by the AS suffix. In the past, consumers would buy software like Microsoft Word and leave the store with a box with a hard copy of the code. Today, consumers are only subscribers to an ever-shifting piece of code. We now have software as a service Monday at Microsoft Office 365, infrastructure as a service Amazon Web Services, Amazon Web Services, and Microsoft Azure, platform as a service Google App Engine and Heroku, payment as a service Square and Dollar, and a dozen others. One market report estimates that in 2023, the software as a service market alone would be valued at $195 billion. A recent comprehensive study of the SaaS model has identified several market philosophy changes that the concept embodies. Among these is what the authors perhaps not coincidentally call the nanonization of products. By this, the authors refer to the growing trend to disaggregate product bundles to the specific functions that the end user cares about. Farming as a service is an especially apt example. While 45% of the Indian workforce is engaged in agriculture, tractors are quite rare, averaging only one per village. Tringo is one of a few platforms that offer farmers individual standalone services, such as tractors, reapers, cultivators, and tillers, that the farmer can access by simply tapping an app or calling a call center. This allows farmers an alternative to ownership to pay only for the specific fragment of ownership if and when it is needed. The advent of the SaaS model represents the growing nanonization of contracts and products. It demonstrates the market need for unbundled goods, the utility of specialization, the importance of small-scale transactions, and the robustness of the supporting technological infrastructure. One chief difference is that in nano parties will transact P2P rather than peer-to-firm. Even with a platform in the middle, the degree of intermediation in nano contracts is significantly lower than it is in the central firm model of SaaS. At this point, it is useful to distinguish nano contracts from seemingly adjacent technologies, the smart contract and the blockchain. Nick Szabo's formative essay conceptualized the smart contract as a digital contract that algorithmically executes its own terms. More recently, Greg Klass offered a sharper definition, defining smart contracts as software, perhaps run on a blockchain designed to execute future exchanges or other coordinated actions between persons who might not otherwise trust one another to perform. An insurance contract, which automatically makes payments if a predefined event takes place, is a typical example. Well, for our purposes, the crux of a smart contract is streamlining contract execution. For this reason, many developers have used smart contracts with blockchain technology. In broad strokes, blockchain is a protocol that runs on tens of thousands of networked computers and creates a decentralized system of trade meant to allow for trust among complete strangers with a central platform. Just as the blockchain allows one to reliably send bitcoins to another, it can be adapted to run smart contracts that facilitate other forms of exchange. And so, while smart contracts do not require the blockchain, they often take advantage of it. A review of smart contracts on GitHub repositories shows that 86.5% were tagged by authors with blockchain-related terms. All of this highlights the key difference between the technologies. While smart contracts try to solve real or perceived problems of execution, nano contracts are tools of contract formation. They aspire to allow parties to create contracts at vanishingly low cost and near zero latency. Whether the exchange is trusted or trustless is not a critical factor in the use of nano contracts. In fact, there are instances where smart contracts are too slow and expensive for the purposes of nano contracts due to the blockchain's relatively long settlement time. Whether nano contracts can achieve their goal, however, depends on their practicability. One practical constraint that nano contracts must meet to succeed in facilitating digital P2P2 contracts in real time, nano contracts must overcome certain challenges. Some of these challenges are legal in nature, while others are extra-legal but still affected by legal norms. By understanding these constraints, we can come to understand what policies can contribute to or stymie the development of nano contracts. Drawing on the transaction cost framework applied by Michael Munger, in the context of the sharing economy, we can identify 5 key constraints. 1. Triangulation cost must be manageable. Triangulation cost, as defined by Michael Munger, refer to the combined costs of locating potential service providers, settling on their price, and agreeing on terms. Triangulation cost must be sufficiently low relative to the benefit or surplus of the transaction. Otherwise, parties will not form contracts. In the context of established markets for commoditized goods, triangulation costs can disappear into the background. But in other markets, they loom large. While there is a large supply and demand for used cars, matching buyers and sellers is challenging. Locating a seller with a specific required model and then negotiating with them successfully involves time, risk, and expense. To remove some of these frictions, people pay car dealerships significant amounts of money to create working markets. The challenge for nano contracts is that the transactional surplus is small. Therefore, triangulation costs must be exceedingly small in comparison to make nano contracts practical. 2. Contract formation must be sufficiently streamlined. The creation of the legally enforceable agreement cannot be too costly, or else parties would use alternative legal arrangements, informal arrangements, or abandon the deal altogether. This issue is familiar from history, as the primary means of contracting at early common law, the covenant, was rarely used due to its reliance on sealed written documents at a time when a significant portion of the population was illiterate. For macro contract today, these frictions are for the most part low, potentially even too low relative to the value of the transaction. But for nano contracts, where the speed of formation is of the essence and the volume of transactions may be extremely large per transaction, real-time expression of assent will add just enough friction and cost to make nano contracting all but impossible. Payment processing must be speedy, secure, and cheap. If the costs of processing payments are too high, the parties will see no benefit in transacting. When buying a car, payment processing costs are usually inconsequential. But for small-scale transactions like buying chewing gum at a gas station, payment processing costs can be prohibitive in relation. Even some mid-scale transactions, like paying workers, are often delayed for weeks because of the alleged transaction costs of paying workers daily. If drivers are to purchase priority at four-way stop signs, the payment must be smooth, quick, and most importantly, inexpensive. 4. Dispute resolution must be available, trustworthy, and efficacious. In the event of a breach of contract, a party can sue in court. But for many small-scale consumer transactions, standard court proceedings are prohibitively costly, making it necessary to use alternative mechanisms such as class actions or small claims courts. The absence of effective dispute resolution has been linked in the research to the loss of significant transactional surplus. In the four-way stop example, what happens if a driver speeds into intersection ignoring the Nano Contract? 5. Enforcement must have a sufficient deterrent effect on non-compliant parties. For macro contracts, enforcement issues arise with some regularity, yet this problem is not sufficiently pressing to undermine the entire system. Some parties evade service, impose delays on the process, and engage in distractions. Yet as long as the party is not judgment-proof or poses no credible threat of making herself judgment-proof, the threat is considered acceptable. If a sanction exists, it must have sufficient bite to ward off unwanted behavior. 2. How nano contracts can meet these constraints. These constraints appear foreboding at first. The nanostakes of nano contracts make the system particularly fragile to practical concerns because at this scale there is just too little surplus to cushion transactional costs. Fortunately, there is a proven answer for most of these issues. The downscaling of macro contracts to micro contracts in the gig economy already answered many of these concerns. These answers largely involve two supporting mechanisms, platforms and reputation, although neither is perfect. The following discusses these answers in order. Triangulation costs. Maybe costs. The gig economy faced this problem in earnest. It is costly to triangulate partners for any deal, and for small deals in particular. That is one central reason why the gig economy had to wait in the shadows for so long. The solution, enabled by technology, is the reinvention of an old concept, the two-sided marketplace. The ancient concept of the bazaar proved something that might otherwise appear counterintuitive. Merchants are better served when they are located adjacent to other, especially in the case of competing merchants, because it is easier for buyers to find an appropriate seller. Companies like Uber and Airbnb adopt this model with an additional spin. They move buyers and sellers to virtual spaces. Another solution that avoids the use of platforms is the use of protocols. Protocols are standards of communication that allow transacting parties to locate each other and communicate directly. One example of a protocol that works at scale comes from blockchain-based exchanges where two strangers can transfer value without the intermediation of a platform. The Internet itself also demonstrates the power of standard protocols in coordinating multi-party information exchanges with relatively little centralized authority. As applied to nano contracts, we can think of a spectrum of solutions to the triangulation problem differing in the degree of intermediation. We can conceive of systems of centralized ordering which are heavy in intermediation, such as those organized by airlines that sell line priority. Less decentralized are platforms which can help maintain a marketplace and means of communication between interested parties, such as the various online stock and crypto exchanges. And then we can think of direct communication protocols, which involve no third-party mediation. Platforms promise, as orally global nodes, no more middlemen besides, of course, the platform. The rise of platforms raises various concerns, perhaps most notably the rise of monopolies in the presence of network effects. Protocols are more attractive on this score, but their design, maintenance, and difficulty of propagating updates are still real costs that must be borne. Fortunately, open source communities and government-funded standard setting organizations provide workable models for such implementation. Contract formation. The solution for the formation problem in the context of nano contracts relies on advanced consent and automated negotiations. This allows the app to negotiate in real time with very little latency or cost even in the form of attention. Some scholars argue that automated contract formation is problematic, at least when the question arises in the context of smart contracts. The contracting script lacks agency, they reason, and so it cannot manifest the necessary assent required to enter into a contract. The same holds for nano contracts, which will likewise have to rely on automated formation methods and advanced expressions of assent. This view of contractual assent is open to debate. While everyone agrees that lack of assent is a bar to enforcement, the procedural forms of expression of assent are a different matter. In modern contracts, there was never an issue with authorization of an offer or acceptance by proxy, as agency law and, well, the ability of any corporation to form valid contracts makes obvious. Nor is the introduction of digital assent especially problematic given how consumers routinely enter and courts enforce online contracts. Again, there are good reasons to worry about faulty assent, but the medium of assent is orthogonal to these concerns. If we question the validity of click-wrap agreements, it is not because the words are shown on a screen, but because they are not read or understood. That nano contracts rely on pre-established manifestations of assent is likewise immaterial. If a merchant considers buying oil and deposits an offer to buy a number of barrels with her agent, telling her to negotiate with a willing seller, if market conditions improve, then the merchant's offer is effective. As long as there is a verifiable pedigree of assent, it matters little for nanoformation that the medium is digital, that assent is pre-established, or that it is conveyed via algorithm. Payment infrastructure. It is surprisingly expensive to transfer payments. These costs make it difficult to implement any system of micropayments. This is because traditional payment systems were designed for large, not small, transactions. As a result, the fees associated with these transactions can be quite high, making them impractical for use in micropayment systems. Fortunately, financial technology, fintech startups, and to a lesser extent, cryptocurrencies are increasingly building solutions to these problems. For example, PayPal offers the option to transfer payments between friends and family at no cost. While this remains a far cry from a costless system of money transfers, developments in the payment space continue to grow. In the meantime, the gig economy resolved this issue through platform-side accumulations. In those regimes, interim payments accumulate after every ride, and the platform sends payment in a single beat, either after a period of time or after meeting a minimum withdrawal limit. Nano contracts must adopt one of three solutions. They can use platforms to accumulate payments before transfers. They can rely on alternative financial tools, like crypto tokens that are cheaper to transmit over an agreed protocol, or they can wait until payment infrastructure improves. A more general lesson from this analysis is that the issue of payments highlights one source of platform market power, the inefficiency of payment infrastructure, and therefore proposes a different avenue for reducing the dependence on platforms. Dispute resolution or solution. Perhaps the most sensitive part of small-state contracts is dispute resolution. The problem is well known. Dispute resolution systems are expensive to operate. Their decisions are protracted. The de minimis doctrine bars litigation, and they are generally a poor fit for small-state disputes. But if disputes are never settled, parties can breach with impunity, undermining the entire system. The legal system has developed several mechanisms to deal with small-stakes disputes, from cheaper arbitration, mediation, and conciliation processes to stake aggregation via class actions and group litigation. Yet, for transactions in very small scales, especially when they are heterogeneous, these solutions can only provide a partial solution. Thus, the gig economy came to rely on two complementary mechanisms: reputation and in-house adjudication. Reputation has proven itself a major disciplining force. To see its role in the private ordering of small transactions, consider the consequences of breach. Suppose an Uber driver does not live up to the expected standard. The car is messy, the driver casually scans their phone while driving, and grating music blares from the speakers. These issues violate the passenger's transactional expectations, but none would command sufficient stakes to warrant a lawsuit. The solution is a personal accountability system in the form of reputation. Uber prompts passengers and drivers to leave a reputational signature by reviewing each other. If a driver consistently underperforms, she suffers the risk that passengers will refuse to ride with her. If a passenger is rowdy or aggressive, she might find herself with no transportation. Research shows that, while imperfect, these systems effectively promote good behavior among users, even in the absence of litigation. Another solution is used by platforms, and normally reserved for more meaningful transgressions, the corporate courthouse. In these internal dispute resolution mechanisms, both parties can explain their position, usually in a limited fashion and without legal representation, and the final adjudication is given to an employee of the platform. The platform will often issue a quick refund, preferring to err on the side of the user and resolve the matter internally with the service provider. Of course, the platform compensates itself for such services, but by putting itself in the middle, it also opens itself to class actions and regulatory interventions. These benefits may ameliorate some of the concerns we might have with platform power. Finally, even though the stakes are small, the legal system is not absent. For example, in the case of a four-way stop, if a driver breaches a nano contract and causes an accident, this will be a higher stake conflict that will introduce the legal system directly. The court will deem the breaching driver as being at fault for the accident, analogous to a driver waving at another to give them the right of way and then crashing into them. This provides another mechanism of dispute resolution. Contract interpretation is an adjacent issue. A breach presupposes the existence of an obligation that was not met, which requires us to first define the scope of contractual obligations. For digital contracts, interpreting intent may seem challenging. This issue was repeatedly raised in the context of smart readers. Indeed, ascribing meaning to code looks difficult. Fortunately, David Hoffman and Greg Klass have convincingly resolved the interpretive question. Interpreting digital contracts requires the same toolset that the common law has always used. Importantly, as scale falls, the scope of transactional complexity falls superlinearly. The room for disagreements in a merger agreement is vastly larger than it is when buying a Coke from a vending machine. Small transactions, small disagreements. The discussion underlies my view that these tiny agreements are real contracts rather than pure transactions. However, as noted at this scale, the boundaries are quite murky, and I can see how some might hold a more transactional view. Winning a judgment is not enough. One also has to collect it. One of the most challenging issues in macro contracts is the problem that defendants are often judgment-proof, or can deliberately become so. As the stakes fall, this problem trends to zero, but a new one appears in its stead. Costs of collection can easily become prohibitive. Filing a lawsuit with a small claims court costs $15 to $20 in New York, $40 in Massachusetts, and $85 in Alabama. This alone could swamp any value from winning a judgment on a nano contract. In micro contracts, there are at least 4 solutions to this problem. First is the use of platforms. The platform has deep pockets and is responsible for residual claims against parties on the platform. More importantly, the platform, as a repeat player, has an incentive to effectively resolve common disputes and compensate disgruntled users even without legal action. Second is the use of reputation. Even if collection is expensive, imposing a sanction in the form of a reputation, it is not. Third is the use of precautions. Platforms do not pay drivers until after the trip is finished, but they charge the passenger in real time. The concern that a passenger will not pay is thus largely resolved. The fourth solution is escrows, a solution that can be easily implemented by platform-free protocols. By depositing payments in an escrow and making the release of payment conditional on performance, many enforcement problems are resolved. In smart contracts, the blockchain manages the escrow, but this is far from a foolproof solution. One must still determine whether a party actually performed according to the proper interpretation of the contract. Doing that accurately requires discretion. The analysis presented in this part explains the primary institutional features that underlie nano contracts and exposes some of the ways policymaking can further their adoption. On this basis, we now move to explore how nano contracts can transform several areas of law: queues, property, employment, and torts. The crux of the analysis will focus on the regulation of queues, an area in which we can easily see nano contracts' transformative effects and failure modes. This will allow us to offer a broader sketch of the issues inherent to other domains of private law. After describing the potential, the discussion evaluates risks, whether legal intervention is needed, and in which form. Part 4. Nano lines, Nano contracts, and the problem of queues lines are a painful, if often neglected, public policy problem. They emerge whenever demand outstrips service capacity. Busy intersections, doctors' offices, concert tickets booths, amusement parks, customer service call lines, plane boarding, fast food drive-thrus, bank tellers, a plane on the tarmac, the DMV, and ticket booths are frustratingly common examples. Lines are often a conflict zone, a common source of friction that every so often erupts into wanton displays of violence, such as in Black Friday sales or road rage on congested roads. But even in their more quotidian form, lines exact a toll on our lives. At the DMV alone, Americans spend an average of 44 minutes per visit. One study estimated that Americans squander $10.30 billion annually waiting to see their physician or dentist. Another study estimated that traffic congestion cost Americans over $7.70 billion in 2019. This is time that could be used for family, recreation, work, hobbies, or romance, but is instead spent waiting in line. Most lines today are not regulated. No federal law specifies line protocol or imposes penalties for cutting in. Instead, the line is often a system of informal social order. But to say that the line is subject to social norms does not mean that these norms are prosocial. Indeed, David Fagundes describes how the nuanced rules of lines are often accompanied by a shadow threat of social opprobrium that sometimes erupts into violence. Jon Bartzel's theory of lines and their cost also helps frame our discussion. Normally, markets allocate scarce resources based on a price system using a system of willingness to pay, WTP. Lines instead allocate resources to those who wait, thus substituting the WTP with a mechanism that Bartzel describes as willingness to wait, WTP. When deciding whether to join a line, an individual assesses whether the waiting is worth her time. Depending on the length of the line, some will join, others will not. As a result, a vicious dynamic emerges. Lines will tend to build up until the point at which they suck up so much time that they are hardly worth the wait. We confirm Bartzel's theory for ourselves every time we balk at a line that is too long. Another problem with lines is how they distribute resources. Most lines adopt an allocation rule known as queue discipline, consisting of first-in-time wins, distributing scarce resources based on who happens to be first in time may meet some formal criterion of fairness, but is neither equitable nor efficient. Insisting on keeping one's seat on the bus when an individual in need boards, citing, "I was here first," evinces egoism rather than care. Recognizing that first in line Heuristics are a crude mechanism of allocation. Some services offer line refinement in the form of priority schemes. For example, on trains, first-to-come heuristics generally determine who sits first. However, a preference is given to people with certain conditions, such as a physical handicap or old age. Some queues use human discretion, i.e., triage, to allocate priority. At the doctor's office, for example, people wait according to the scheduled appointment time. But the staff is given the discretion to give priority to a patient who suffered acute trauma. In specific cases, social status is used to award priority, hence the existence of VIP lines. Some scholars express hope that we can solve problems of waiting in line now that online lines are an option. Bartzel's theory helps us understand why this is not quite true. Online lines do nothing to produce any excess service capacity, and so the resource in question is just as limited as it originally was. We still must bide our time until the specialist is available to see us, our cortado is brewed, and the mechanic gets to our car. True, it is less painful to wait at home than it is to wait at the post office, but this sometimes quite counterintuitively worsens the problem. Once lines abandon the implicit cost of standing in line, they lose the signal inherent to the www mechanism. When that happens, many more individuals join the line. Some of them with a fleeting interest in the product, some with none at all. Some are scalpers and others have bought all of them, inflate the line and distort its desired allocation relative to a world where those in need could ensure allocation by waiting in a physical line. An online queue can make matters worse. Absent some credible signal of need or merit, online queues are assured to be neither more fair nor more efficient. Yet even though the line system is hard to justify on grounds of equity or efficiency, the status quo proves recalcitrant. This is due to twin fundamental problems, which we can dub the verification and the grasshopper problem. The verification problem arises from the question, how can you tell whether someone in the fast lane is indeed in an urgent situation? Many people would claim a special need just to avoid a line. Thus, it might be necessary to install a costly verifier like a triage nurse at the emergency room to make judgments. To solve the problem, hospitals must now employ a full-time health practitioner who spends their expertise on administration rather than care. Another type of cost is the verification process itself. Patients may need to produce documents showing blood work, special medical conditions, or urgency. And at the risk of infinite regress, there will often be a line to the triage itself, as visitors to the emergency room know. Then there is the cost of the mistakes the verifiers are bound to make in good faith, and we're not assured of that good faith. Given the discretion necessarily allotted to verifiers, some of them abuse their position to give priority to those who have an in with them. In the shadow of all of this, we sometimes see the emergence of a new wasteful dynamic where people learn how to game the verifier. In the organ transplant context, some doctors exaggerate their patients' needs so that the system will give their patients priority in line at the expense of the less fortunate patients who remain to languish in line. Even when we can resolve the verification problem reasonably well, we are exposed to a second-order problem, the grasshopper problem. While many of us are Aesop's ants in the sense of planning for the future, others are carefree grasshoppers. A veritable grasshopper might live by Stigler's maxim that if you have never missed a flight, you are spending too much time in airports. He always leaves late for the airport. And to one and all, and most of the airport, he will occasionally arrive so late that he's bound to miss his flight, unless that is he gets to skip the airport security line. As it turns out, airport personnel will often do just that because they attempt to help passengers in a hurry arrive on time by letting them skip the line. What is so troubling about this example is that this is not an example of the failure of the verification system. The verification method works perfectly here. The grasshopper is in a real rush, and the airport verifier is correct to flag him as someone in need. The problem is that by giving the grasshopper priority, The verifier rewards him for his reckless planning at the direct expense of other passengers who are better planners. This points at the general problem with verification systems of triage. They create unintended grasshopper problems that exacerbate the pressure on the already scarce resources. Nano Contracts circumvent this patchwork. They offer a solution to the problem of queues by creating a protocol for parties to directly, quickly, and potentially anonymously negotiate the allocation of places in the line among themselves. A nano contract can just as easily be used to auction off a place in line at airport security, at a baseball stadium, and at the pharmacy. It can also be used to pay email recipients to afford special attention to one's email, transmit data faster on the internet, or get priority for technical support. Notably, this trade does not come at anyone's expense. If the person third in line is trading their places with the person who is last in line, only the two trading partners are impacted. This places line trading transactions in the coveted echelon of Pareto improving transactions, deals where at least one person is made better off without harming anyone else. This is because if the compensation offered is too low, or if one does not want to wait any longer, they can refuse the switch. It is also possible, although less likely, that nano contracts would allow a latecomer to jump to the first place in line, pushing all else back a spot if the latecomer is willing to compensate all line waiters for the added wait. And if people do not quite remarkably, nano contracts simultaneously solve the verification and the grasshopper problem without the need for costly triage. They solve the verification problem because it is not enough to just say you are in a rush. The user must put their money or tokens where their mouth is. The more others need priority, the more one must stake. This verifies that the user truly values priority. The grasshopper problem is similarly resolved. The grasshopper problem is similarly resolved. If my tardy friend had to pay based on how many people he jumps in line, he would certainly start planning better. The requirement to pay for priority rewards good planning and moderately sanctions grasshoppers. Key to this entire system is voluntary trade. Unlike the current system, which imposes an arbitrary line, nano contracts let people have a choice. I can retain my place in line if I am in a hurry or need, or I can choose to wait a bit longer and be compensated for my time. Especially in settings where transactions are anonymous, we need not worry about coercion or duress, no more at least than we must worry about bullies who cut in line or the connected who are given priority over. Unlike systems like priority boarding, the compensation goes to us, not to a third-party actor. The four-way stop is illustrative. It allows all cars to quickly determine who will go first while remitting payments between line participants. Another example is the food delivery service, DoorDash. After making the order, the user is given the option to choose a tip for the driver. Because the driver views the tip before taking the order, this tip can be used to gain priority in the delivery queue. A related advantage is the P2P nature of the nano contract system. Why many firms have seized on the inefficiencies of the status quo and commoditized lines. For example, Six Flags sells the place in line of those who arrive first to those willing to pay more. In socialist countries, there are fixers, variably known as tokachi or marshas, who offer to get people ahead in line for the right fee. In the United States, just often accept bribes in the form of tips to give preference to certain guests. Concert venues sell VIP tickets for a hefty premium and allow their holder to avoid the line and enter the venue early. Unlike nano contracts, where payments are remitted to other people in line, in these queue product transactions, the firm is earning the revenue. Because lines are a source of revenue, companies like Six Flags may have less incentive to shorten lines. This is a point about the status quo that must be emphasized. Lines are already commercialized, but not in a P2P manner, like a nano contract. Those queue products are not equitable, fair, or even efficient, resulting in incentives to preserve the lines. Critically, a nano contract does not even have to use money. Oh. Consider the course priority rules used by the Kellogg School of Management at Northwestern University. Naturally, some courses are in high demand. Standard systems of registration favor those who plan and sign up early, but not necessarily those with greatest interest or need in a particular course. The university decided to implement a Q auction system. Every student receives 3,000 token points. Students bid with no maximum on each of their courses according to a set procedure. At the end of the process, a line priority emerges that reflects the students' priorities for different courses. In much the same way, tokens can be allocated for traffic priority or other forms of access. The very existence of nano contracts mitigates the risk associated with life's unexpected events. If we ever find ourselves in a real emergency, we can get to our destination sooner, even if a bit poorer. While we must pay for priority, at least we can get it when we need it. This is a great improvement over our congested roads, where all independent of need, urgency, or medical condition must wait. And as alluded, one does not have to use the system every day to benefit from it. It is enough for one to know of its existence to insure oneself against risks. If line trading is profitable, it is natural to wonder why we do not see more of it. The answer comes from the enlightening work of Professor Felix Oberholzergy of the Harvard Business School. Oberholzergy sought to examine why markets for time rarely exist. To that end, he had 10 researchers approach 500 individuals who waited in line for the cafeteria, the train station, and the DMV. Pretending to be in a hurry, the researcher offered to cut in line in exchange for a $0, $10 payment. His first finding is consistent with much of the above. The more money offered, the more people were willing to forego their place in line, from 45% with no payment to 76% with $10. However, only a small minority of people agreed to actually take the payment. They simply let the researcher pass them while refusing payment. It seems that most people used the offer of money as a makeshift verification mechanism, but were prevented by social norms from actually accepting it. This is why higher amounts yielded better responses, even though they were not collected. The problem, of course, is that when payments are not remitted, the credibility of payment offers vanishes. This allows those who do not play by the social rules to manipulate others. Interestingly, Oberholzergy pushed the line a bit too far. He approached some of the people who previously let others cut ahead of them in line a second time. He offered them again payment to cut ahead. In all cases, he was summarily rebuffed. Most of them appeared upset, some angry, a few outright hostile, suggesting that it was probably not safe to continue the experiment. He thus concluded that the rarity of markets for time lies in the perception that exchanges in this market are viewed as one-time favors. While favors have a positive connotation, they obey a much more complex logic. Not because line trading is viewed as a favor, people act with outright hostility when they feel that their boundaries are transgressed. And because it is uncomfortable to ask for a favor from a stranger, many of us feel uncomfortable asking others for help, even when we are in a real hurry. At the same time, we are all too familiar with those who do not concern themselves with the opinions of their peers and liberally cut in line. Nano contracts do much more than facilitate exchange. They create a norm in which asking for priority does not require calling for special favors. They also implement a mechanism that reduces the friction involved in trades for time. This highlights a major contribution of nano contracts, opening up opportunities of mutual interest that are shrouded today by social and transactional frictions. The overall effect is, of course, nuanced. While this may increase people's willingness to leave late, this is not necessarily a bad outcome. Research shows that when resources are scarce, people prefer systems where those who wait longer receive greater compensation over systems where priority is assigned, based on either a system of lottery or surge pricing. If the success of priority access in parks and airplanes is a guide, consumers adjust quickly to such market norms. Below policy on nano contracting lines. Nano contracts offer a general solution to lines. In doing so, nano contracts solve significant problems like permitting people in a rush to gain priority, transferring payments to people with greater patience, and avoiding the cost of verifiers and grasshoppers. But the proliferation of nano contracts would also entail a market creep into areas previously governed by social norms. They also engender distributive concerns regarding their effect on those living close to the social margin, alongside other efficiency, political, and ethical concerns. Whether the legal system should regulate nano contracts or even permit them at all depends on our evaluations of these potential concerns. Perhaps the broadest and most sustained critique of line commodification is that offered by Harvard philosopher Michael Sandel. In his book, Sandel seeks to defend the separation of lines and markets, advocating for what he calls the ethic of the queue. This moral system holds that allocating goods through lines is desirable in and of itself, at least relative to price mechanisms. Well, a central tenet of the queue ethic is the belief that WW2 is better than, or at least not clearly worse than, a WTP system. If society wants to allocate resources to those who value them the most, WTP is limited, Sandel argues, because it does not reflect real need, but rather the ability to pay for the good in question. He notes with visible annoyance how baseball fans who sit in the expensive front rows often come late and leave early, manifesting only passing interest in the game, unlike the other less affluent diehard fans. Lines further embody a democratic ethos, he claims, visibly affirming our equality, as we all languish in waiting regardless of wealth, race, or creed. Thus, Sandel finds the queue ethic to be a superior alternative to market mechanisms of allocation. As a general argument, Sandel's critique is unpersuasive. It would require a great feat of line drawing to explain how a market economy that allocates most of its goods through markets and prices suddenly turns unethical when it comes to lines. Sure, markets and prices have their discontents, and there are those who condemn all market transactions as morally suspect. But in a society where it is permissible for dealerships to sell, say 2023, Subaru Outbacks based on WTP, how can one justify the dissipation of this principle at the line to the dealership? This position is mystifying because lines are downstream of the price system. Lines tend to emerge when goods are being sold at a price that lies below the market clearing price. In our society, the manufacturer is generally free to set prices as it sees fit. If it is permissible for Subaru manufacturers and dealers to raise prices until no line exists and then offer sale prices when they have exhausted the initial pool of buyers, why is it a moral wrong to keep prices low and sell line priority instead? The commitment to the queue ethic is especially puzzling in a world where firms already commoditize lines as queue products. Sandel himself notes that in recent years, selling the right to cut in line has come out of the shadows and become a familiar practice. These products are largely normalized. Largely normalized. As Fagundes notes, while most customers may dislike them, VIP queues do not represent norm violations. Perhaps there is an ethical theory that condemns expedited shipping, but that condemnation certainly has not been widely accepted. It is also not the case that W2DU is a better measure of value than WTP buying. While the comparative literature is not expansive, the existing evidence that suggests that WTP indeed carries a strong signal. One empirical study examined the decision to purchase a priority pass relative to the decision to wait in the normal line. It found that those who pay value priority much more than those who wait in line. A different study found no correlation between willingness to pay for a shorter line and economic status, which suggests that payments do measure a real difference in valuation. The darkest side of the issue is that, from an egalitarian perspective, we must be cautious about championing WTP. There is an implicit assumption that somehow WW is more progressive than WTP type. The idea seems to be that because our society has inequality in the distribution of material goods, WW is an equalizing force. On reflection, this is wrong. To put the point bluntly, we simply do not live in a society where free time is equally divided. This is the very thrust of Thorstein Veblen's leisure class framework. A struggling mother of four working a minimum wage job will not see much benefit from a system that rewards those who can spare the time to wait in line. And of course, money and time are often fungible, making inequality in one transform into inequality in the other. For instance, some people hired line waiters, paying them as much as $6,000 to gain the right to watch the seminal oral argument in the Supreme Court on same-sex marriage. Even when people wait for themselves, reliance on WW can be regressive. Lawyers should be especially sensitive to this point. Research on the welfare system and eviction shows that time requirements create serious obstacles and stress for poor communities. A recent study shows that poor tenants face evictions on a large scale because they cannot afford the time involved in public transit to the courthouse. Even though they are paid less, those with less financial resources do not sit on troves of free time. I want to make a stronger argument. In many situations, nano contracts will be more progressive than the status quo. This is partly because there is nothing inherently beneficial to the economically disadvantaged under the current system. One's position in line, rich or poor, is often determined by luck. Nano contracts mitigate some of luck's harsh effects by offering people a meaningful choice. They can elect whether they want to retain their place in line or whether they want to spend a few more minutes idling in exchange for direct compensation. If a person has a bit of extra time, they may be able to leave the post office with a few extra dollars in their pockets. And if they are in a rush, they can just keep their place or pay a little to get priority. As long as choice is preserved, nano contracts offer a potential improvement over the status quo. By contrast, attempts to maintain the status quo often unwittingly harm those who are less well off. There may still be a residual concern with a world in which the wealthy tend to be first in line. Indeed, that is already the case under the current System Elite Airline Members Board First. Toll roads give priority to those who can afford them, and buy tickets create a fast track for those who can afford them. Nano contracts, however, offer a way to remedy some of these issues. If we identify a systemic access concerned with a specific type of line, it is possible to issue tradable tokens on the platform. We can allocate priority tokens to people on a monthly or annual basis, which can be used in addition to or instead of money. This offers another way to target vulnerable parties, which is not possible under the current system. While I think Sandel's critique fails in general, I do believe that there is an important kernel there, and that it offers some valuable lessons for the regulation of nano contracts. Rather than a blanket objection to commoditized lines, we should be attentive to the type of good that is being allocated. It is one thing to allocate primary resources such as Subaru Outbacks and tickets to baseball games based on WTP. It's quite a different matter to allocate publicly provisioned goods in this way. This is because public provisioning already implies a judgment that market allocation of the underlying good is faulty. Prominent examples where notions of Q ethic may be applicable include the line to the voting booth, kidney transplants, a place in line for the draft or jury duty, fresh water during a natural disaster, waiting for a court to render a judgment, or access to medical resources during a pandemic. What ties these examples together is that society decided that the goods should be allocated outside of markets. In those cases, it will certainly be true that commoditizing the line would undermine this goal. Explicit markets and lines in such instances may be offensive to our sense of equality and justice by expressing the view that some people's rights, votes, lives, or sufferings are more valuable than those of others. By creating markets in those domains, we risk changing the very nature of the good itself. As Sandel notes, how a good is allocated may be part of what makes it the kind of good it is. Another effect is the crowding out of social norms. If an elderly, frail woman asks a person to get ahead in line to the voting booth because she has a doctor's appointment, social norms dictate the answer to be sure, ma'am. Rather than that will be $2.50. By focusing our attention on these types of goods, we can come to appreciate the need to regulate and sometimes even ban nano contracts in certain contexts. The quest for policymakers will be twofold. One, identify these contexts, and two, find measures that can actually work to limit the proliferation of nano contracts. To an extent, legislators have already begun this quest by making it illegal to trade in certain rights. Interestingly, there is no specific sanction for Q trading in the context of public provision of supplies during an emergency, but it is quite likely to be frowned upon. At the same time, it is important to recognize that limiting private contracting, side deals, and shadow bargains is difficult. As the Oberholzer G study shows, some lines are partly protected from the incursion of markets by social norms. As particular applications of nano contracts can be designed to allow people to trade under the screen of anonymity, compliance with social norms will become a challenge. Therefore, it is important to heed the constraints identified in Section 3B, as its solutions usually involve reliance on broader institutions, and regulators may have more success regulating these institutions than the parties themselves. So far, I have argued that nano contracts have progressive effects and bring social utility. However, despite nano contracts' ability to solve the grasshopper problem, there is one additional efficiency-based concern. This is the problem of cloggers. Recall the four-way stop example. Stop example. There, I assumed that those four drivers were already on the road. But nano contracts can also induce more people to go on the road. With nano contracts in place, cloggers may find it profitable to drive aimlessly in the hope of collecting money from drivers who are in a rush. Cloggers introduce delays to all drivers, increase the cost of travel for drivers in a rush, and waste their own time. Despite this real possibility, cloggers do not deal a fatal blow to the use of nano contracts to solve queues. This is because cloggers must bear real cost when they engage in clogging. Airlines oversell flight tickets, calculating that some passengers will miss their flights. When flights are overbooked, however, airlines offer handsome payments to people who are willing to forgo their place in line. Yet, there is no evidence of widespread abuse by cloggers who strategically book busy flights. Because of these costs and the relatively modest payments from nano contracts, it is unlikely that clogging will be widespread. Even in the situations where clogging does emerge as a problem, we should consider two responses. One is indifference. A small degree of clogging is tolerable, given that the payments go to people who demonstrably lack more productive avenues to eke out a living. The second is the adoption of keyhole solutions, like banning clogging and imposing restrictions on clogging behavior. E.g., cars that drive aimlessly for hours will not be able to collect payments. In summary, nano contracts offer a natural solution to the problem of queues. Evaluation of their merits suggests that in most cases there are real advantages, both ethics and efficiency-based, to their adoption. True, we need to exercise caution in the case of publicly provisioned goods, as nano contracts can crowd out social norms and corrode the goods themselves. However, for the vast array of products and services, nano contracts offer a significant improvement over the current system. Payments made through nano contracts can be progressive, providing people of limited means with another way to monetize their spare time. Nano contracts also reward planners and waiters while relieving all of us from anxiety about the future. This is not to say that a hands-off regulatory approach is necessary. Regulatory involvement will be needed for tasks such as issuing tokens and delimiting permissible uses. But as a general outlook, nano contracts hold important potential for improving the social problem of queues. Part 5, Nano. Nano leases and excess capacity. Most of our personal resources are underutilized. Take the personal household. The average car sits idly for 22 hours a day, i.e. 95% of the time. The average drill is used for 12 minutes a year. A large percentage of homes are barely used. Think of the kitchen, bathroom, and shower, which are only used for a few short hours each day. We wear only one shirt at a time and leave every other shirt to sit idly for weeks at a time. Even commercial assets have a high degree of downtime. Office space is used only for the workday, and since the COVID-19 pandemic, much less. Restaurants normally only operate for half of the day, despite occupying expensive real estate. Even factory machines rarely run 24/7. Idle assets account for a sheer amount of waste. Nano Contracts offer a way to utilize this idle capacity through nano leases, approximating Lobel's vision of ushering in the end of idle capacity. Consider a working example from a new startup called Helium. Most people have underutilized broadband internet capacity, with median households using only 1/3 of the capacity used by power users. Helium offers people with such excess capacity the option to install a router that grants casual access to passers-by who pay for access. The stakes and duration of every transaction are small and short, making them into a clear example of a nano contract or even a nano lease. The potential of a service like Helium goes far beyond saving on roaming charges in a new city. It opens up the ability for broad coverage for Internet of Things, IoT machines, offering ways for electronic scooters, wearable objects, parking meters, cars, and even dog tags to communicate with the world through direct internet access. Another impressive example is food sharing. Olio is a popular food sharing platform that allows businesses to donate excess food to food insecure individuals. In January 2021, Olio facilitated around 14,000 food exchanges each day. While not the same as an individual-to-individual nano lease, the platform is arguably demonstrative of the viability of a marketplace for excess cooking capacity. We might imagine neighbors offering an extra pot of stew, a weekly meal prep, or a fresh-cut salad on demand. Germophobes might balk, but the indolent and the bon vivant will celebrate. Lastly, startup toolery allows people to rent out their clothes for a short duration. A last illustration is something most of us would not even consider to be capacity: aerial passage rights over land. It is quite clear that drones will become an increasingly important mode of goods delivery, but their success depends on the ability to pass over land without violating the aerial rights of landowners on their delivery path. The issue is highly contentious, and the drone industry tries to promote legislation that would extinguish landowners' rights to exclude drones from their low airspace. An alternative solution to the problem is to use nano contracts. If drones can directly negotiate in real time with landowners, they can offer a consensual form which respects homeowners' rights without blocking new technology. Beyond these examples, many assets owned by individuals can be converted to use nano leases. Used books, garage-stored bikes, PC computing power, right-of-way through their backyard, video games, a mailbox address, extra closet space, access to the yard water hose, garage access, fruit trees, and muscadine vines. Once transaction costs are low enough, the options appear unlimited. A few substantive caveats are in order. First, some physical costs and limitations impede nano leases. A lawnmower, to use an example raised in the literature, still needs to be transported from yard to yard. And given high demand during the weekends, lawnmowers may not be perfectly susceptible to sharing. Some degree of idleness is inevitable, even with ideal nano contracts. Second, dispute costs can arise whenever a person returns the lawnmower broken, downloads illegal materials using our IP, or commits the cardinal sin of putting a dog ear in our book. Third, and more deeply, not all underutilization is wasteful. As Fennell elucidates, the periodic idleness of seemingly redundant assets does not necessarily bespeak inefficiency. There is more to an asset than its utilization. It might be narrowly efficient to have someone wear my shirt when I'm not wearing it, but not having unique access to it will disrupt something very basic about how I perceive myself in relation to my property, not to mention questions of hygiene. Peggy Radin's work goes to the heart of the matter when she writes, how certain objects we possess are closely tied up with doer personhood because they are part of the way we constitute ourselves as continuing personal entities in the world. My grandfather's old pipe is a source of value to me, even though it is never utilized. We want to be sympathetic to these arguments, but also avoid stretching them too far. For many assets and many individuals, the reason why assets were not shared with others had little to do with autonomy, ownership, or necessary slack, and probably more to do with the transaction costs involved in sharing them. The gig economy has shown that once transaction costs are attained, many people are happy to let strangers use their private homes, drive their cars, share their parking space, and even provide excess storage room in their closet. People see the trade-offs in their lives differently than we do, and respecting those choices is part of respecting their autonomy. The benefits of nano leases go beyond putting idle capacity to use. What's beyond capacity to use? The lessors, monetizing underutilized assets, can be an important source of income and help defray bills while freeing up space. Nano leasing can improve household liquidity, a deep concern that affects low-income households with particular force. The lessees, the availability of nano leases makes it less necessary to own, license, or rent goods in the first place. For example, knowing that we can reliably access a laptop on demand can make it less necessary to travel with one. Leasing also has the advantage of allowing specialization. Owning one's own bandwidth connection involves research into the following: conducing market analysis for providers, selecting the correct router, identifying the optimal transmission channel, and updating and sometimes even replacing the firmware. But nano lessees are spared all that trouble. They decide how much they are willing to pay and then just connect. Potential lessors can specialize in providing bandwidth services, letting others enjoy their acquired expertise. Heralding nano leases is the rise of the XaaS model discussed above. Consider in particular the model of product as a service. When asked, under this model, a firm takes a product that it would normally sell and instead offers it on a pay-per-use or subscription service. For example, Homey offers individuals the ability to treat their washing machines, dryers, and dishwashers as a service for which they pay per use, with the company being responsible for maintenance. A more familiar example is digital storage as a service. Local storage was a significant concern before cloud storage, making it necessary for individuals to own a large volume of storage media, disks, CD-ROMs, hard drives, USBs, and so on. Today, cloud storage has deeply transformed the notion of owning one's data. Yes. Unlike these top-down transactions, nano contracts offer the ability to connect individuals with other individuals in a P2P fashion. This decentralized model has important promise, especially in contexts where spatial concerns are at issue. If Mr. Whiskers slips through the door into the city, we can be sure to locate him using his tags and local internet network. Broad access to home laundry and ironing can make travel anywhere much more comfortable. The ability to reliably use my neighbor's laundry machine will spare me the need to buy a machine or rent a larger apartment. Once a sufficiently broad network of continuous supply is achieved, many other nano leasing opportunities currently covered by the fog of the future will become visible. After all, we can trust that wherever we go, we can purchase milk on demand, making it unnecessary to haul a cow with us. B. The legal policy on nano leasing. Nano contracts allow us to better utilize our resources, which challenges our traditional notions of ownership, possession, and renting. The shift from owning things to leasing them, particularly when applied to a wide range of assets, represents a conceptual shift. In the Demsetzian framework, the primary evolution in property regimes takes place between systems of mutual governance to systems of private property. Nano contracts suggest that there is another potential move in the folds, from property to contract. We can view nano contracts as an invitation to engage in an important conversation about the social meaning of the transition to a world where governance is dominated by the latter. The following discussion briefly outlines some key concerns. One concern about nano contracts is that their use challenges the concept of private ownership. Under the Hegelian developmental thesis, the ownership of at least some private property is essential to the development and maintenance of capacities and self-understanding that make up free personality. This raises interesting questions for nano contracts. Is something severed when we no longer own basic property? Is the leasing self different in important ways from the owning self? What aspects of property are tied up to autonomy, rights to exclude, abilities to break and shape, or the temporal continuity of our relationship to objects we can call our own? Perhaps something profound is lost when our interactions with goods are tentative and time-bound. These are questions that future property scholars will want to debate. The endowment effect, a cornerstone of behavioral economics and a highly influential idea in legal scholarship, suggests that ownership imbues goods with special meaning. In experiments conducted around the world, researchers found that people who own goods value them more highly than they do when given the option to purchase them. However, when goods are designated as trade goods, this effect disappears. For those who believe in the endowment effect, nano-leasing should give pause. It seems that hyper-leasing, either as a lessee or a lessor, could fundamentally alter the value people endow in their property. There are also consequences for the notion of leasing itself. For example, Airbnb has not only changed the way people monetize their property rights, but it has also changed the meaning of ownership. People who rent their homes on Airbnb often make changes to make the space more inviting, keep it cleaner, and install better amenities. While some of these changes are innocuous, even salutary, they can also redefine how people think about their homes, from a private sanctuary to a place of business. Contrary to what one might expect, the erosion of ownership may be compatible with an array of anti-consumerist, environmentalist, and Marxist philosophies. Under these theories, private property and excessive consumption are objectionable. Some of these ideas can be traced back to the work of economist Thorstein Veblen, who argued that conspicuous consumption, fueled by a desire to signal social status, drives consumers to consume in excess. The result, as explored by thinkers like Juliet Schor, is an overconsumption that contributes to environmental degradation. One solution advocated by these movements is the sharing of resources among members and the removal of the stigma around owning few items. Communal living arrangements such as the family, private clubs, and moshevim and kibbutzim all exemplify models of shared property governance. Nano contracts involve a profit motive and can lead to concentration of capital, so they are by no means equivalent to these arrangements. Nevertheless, they may also address concerns with private property and waste. Nano contracts allow multiple people to share the same goods and thereby considerably reduce private ownership. The greater utilization of assets would reduce the need to overproduce items like drills and tractors, mitigating the toll on the environment. To the individual, nano contracts could offer a roadmap to a self that is not anchored by the need to own. Life as a service, if you will. Jurisprudentially, nano contracts also have a disruptive effect, going to the very heart of the legal notion of property. As Henry Smith explains, property is an architecture, a system, rather than the collection of isolated functions implied by the metaphor of the easily separable bundle of sticks. As Smith argues, property is, first and foremost, about the ability to put assets to use, with other features, e.g. exclusion rights and leasing rights, emerging only as means to this end. Accordingly, many of the features of property law are contingent. For example, the right to exclude is not an inherent aspect of property, but rather an attempt to solve a problem of transaction, or more specifically, information costs. Thus, in a zero transaction cost world, we could use all governance all the time, whether supplied by government or through superfine-grained contracting among all the concerned parties. Nano contracts arise from asymptotically low transaction costs between a large mass of users. Thus, they offer the ability to develop radically different governance mechanisms, far more fine-tuned than crude notions of monopoly governance implied by today's property regime. Contracts do not go unscathed either. Nano leases straddle sales, leases, and licenses, and present a difficult question for their classification. For Article 2 of the UCC, to apply, the contract must involve a sale of goods, which means the passing of title. While this may be true of some Nano Contracts, Article 2 of the UCC will not apply to, say, bandwidth access agreements. Further, the transactional scale of Nano Contracts makes Article 2's overall regulatory approach far less appealing. Unlike sellers of heavy equipment, it makes little sense to offer parties to nano leases extensive inspection rights or insist on perfect tender rule. These rights become increasingly less applicable when the scale is as small as someone who is licensing picking rights from their prolific mulberry tree. Some transactions may be thought of as nano leases, thus controlled by UCC Article 2A. However, at this scale, leases become hard to distinguish from licenses. The proper classification has significant practical significance as it affects matters such as jurisdiction, termination rights, and the availability of self-remedy. Under 2A100 and J, a lease involves the transfer of possession, but a transfer of possession is also consistent with a license. To distinguish the two, courts find licenses for non-exclusive grants of possession, revocable agreements, and when the agreement's scope is limited to in personam rights, although this latter examination often appears conclusory. The problem is that an extremely short extension of possession is often indistinguishable from exclusive possession, and revocation at these time scales is often irrelevant. Thus, when a nano contract provides a person with fleeting access to another's jumper cables, these issues become extremely hard to disentangle. In terms of policy, one major concern with nano contracts for excess capacity is distributional. Take the case of broadband. As noted, most users underutilize their capacity. As a result, broadband suppliers can offer better pricing, factoring in actual average usage rates. If certain home users start commercializing their excess capacity, actual usage will rise, increasing service costs for the providers. It is likely that costs will rise not only for those who nano-lease access, but for everyone. This cross-subsidy creates unfairness between consumers. There are instances where increased capacity has broader and less obvious effects. In an apartment building, it matters whether an apartment is utilized by a single person or revolving strangers, not necessarily because of the apartment space capacity itself, but because of greater utilization of shared resources such as elevators, a sense of community, or simply noise. At the same time, nano contracting can reduce net capacity usage. Because Uber increases the revenue from driving, it can lead to greater road usage. Nonetheless, a study on Uber's effects with respect to road capacity found that Uber actually reduced congestion by increasing vehicle occupancy. Further, surge pricing possibly reduces the capacity load in time of great demand. A study of car sharing found improved welfare, especially among lower-income consumers. The authors proposed that resource sharing can be an economic force that democratizes access to a higher standard of living. What contracts can do, contracts can also undo. One lesson from copyright law is that there are strong upstream pressures to use contractual schemas to limit the ability to utilize property rights downstream. If aggressive nano-leasing reduces demand for goods, if it increases bandwidth usage, or if it allows owners to extract rents from goods, producers may seek to use contractual mechanisms to prevent nano-leases. As an analogy, producers of electronic devices have made it deliberately difficult to contract out repair services of one's devices outside of the producer. In a similar fashion, internet providers may limit the ability to share bandwidth in its terms of service. In the case of repairs, this limitation led to the formation of a large advocacy coalition demanding a right to repair. Should there be a right to nano-lease? In sum, nano-leasing offers a way to drastically increase the utilization of assets. This effect can usher in great social advances, contribute to the ethics of consumption, and reduce the resource load on the planet. These benefits notwithstanding, a move from property to contracts raises several difficult concerns. There is the philosophical question about autonomy and self-definition in a world where little belongs to us. Then there are some distinctly legal questions about the classification of nano contracts and the type of rights that should be associated with a nano lease relative to a macro lease. Distributionally, nano contracts have ambiguous effects, and there are at least some areas where few will be enriched at the expense of the many. The passage of ordinances in many cities against short-term rental exposes how expanding rental rights can have significant effects on communities. As we move to a nano contract future, these questions will become increasingly important. Part 6, Nano Gigs A. Nano work and the problem of casual work, nano jobs, like keeping a watchful eye on one's laptop for a minute or helping to replace a punctured tire, become possible with nano contracts. What would be the impact of nano contracts on labor markets? For a close comparison, the gig economy has had a profound impact on the lives of millions of Americans. Estimates are speculative, but one finds 59 million adults participating in it, almost 36% of the entire U.S. workforce. This transition from jobs to gigs represents a shift towards the utilization of skills on a more casual basis than traditional employment contracts and independent contracts. However, the gig economy has not always been a positive force, and the impact it has had on employment and employee rights has been a major point of contention and focus of scholarly debate in recent years. There is plenty of room at the bottom, even in labor markets, or, indeed, services such as Turk, wherein a worker might be paid $1 to watch a 1-minute video and write the first 5 words that come to mind, already blur the line between micro and nano contracts. Many people are willing to use their idle time, such as during commutes or in between meetings, to engage in short-term paid tasks. For example, individuals with relevant expertise could provide casual customer service, solve technical problems, label data for AI projects, monitor security cameras, clean public spaces, or recharge electric scooters. Just think of the users of public transportation and how they can leverage the long circuitous rides if they could access nano jobs on their commute. The potential applications of nano contracts in labor markets are vast and could provide new opportunities for individuals to earn income and for businesses to access specialized skills on demand. The rise of the gig economy has made the point straightforward. Why? The point straightforward. There is a large untapped market for labor. Tapping into it can vastly improve the fortunes of millions. Nano work offers workers the opportunity to engage in work with little commitment. There is also an important, less obvious progressive element to fleeting nano engagements. One lesson from policies like California Bottle Bill, whereby a small payment is paid when bottles are properly disposed, is that providing opportunities for people to work on a casual, non-committed basis can serve as an important anti-poverty tool. The legal policy on nano work, the legal policy on nano work, considering the regulatory implications of nano gigs, requires a sense of their effect on the rights of workers. A good source of inspiration here is the gig economy, although in some ways it is too early to say what the net effects are. To borrow from Joe in Life, one persistent line of critique against the gig economy depicts its value as mere regulatory arbitrage. That is, rather than providing any actual value, platforms like Uber and Airbnb, who characterize themselves as mere providers of a software app, in fact, do so to avoid many of the safety, hygiene, and other regulatory risks that apply to taxis and hotels. Siren economy firms flourish by reproducing existing services without the same societal restrictions. Recent work has attempted to evaluate these concerns. Using an extensive data source, researchers from Harvard Business School and the London School of Economics concluded that this critique may be overstated. They found that regulation explains part of the value of such labor agreements. In fact, they find that this economy provides tremendous value to workers who, relative to their alternative opportunities, earn staggeringly 26% higher wages. Another critique comes from the potential transformation of employment law to contracts. Employment law is meant to create a mandatory framework that constrains private contracts and offers some minimum protections for workers. The gig economy has been accused of creating a new class of workers, what economist Guy Standing calls the precariat, whose source of income is ever contingent. Many legal scholars, such as Catherine Fisk, have thus called for an expansion of labor protections to these workers. A large legal battle is currently underway attempting to define Uber drivers as employees of Uber. Recently, the Supreme Court of England ruled that Uber drivers are workers, although it left open questions of whether they are also employees. On this side of the pond, Uber drivers are still not recognized as employees, although the legal battle continues. The difficulties imposed by Uber to legal classifications are an order of magnitude larger for nano contracts. If Uber drivers' involvement with the platform can be measured in hours, then nano work will be measured in minutes at most. This will make it ever more difficult to allot nano workers vacation days, social benefits, minimum wage, and other employment protections. The policy reaction can be to adapt labor regulation to the nano economy, but it may be that little good has come from trying to force the square peg of how people work today into the round hole of 1930s era labor law. Instead, it might be necessary to expand the social net, either through universal basic income or other social programs, regardless of employment status. A different type of reaction comes from focusing on those who live the most precarious lives. Some forms of nano-employment solve a long-standing problem among those who face barriers to joining the formal job market for reasons such as discrimination, criminal history, and mental wellness. One unexpected lesson from bottle recycling programs is that they provide an important source of income for extremely poor households, by one estimate as much as 6.8% of their annual income. Nano-employment, like the bottle recycling example, can be an important anti-poverty mechanism. Before concluding this section, a brief remark on work and the self. Just as much as nano leases solve the problem of asset underutilization, nano contracts can be cast as solving the problem of labor underutilization. But is this a problem? Well, yes, a problem. To some, idleness and leisure are activities or anti-activities that help define the self. When one works, one is under the command and prerogative of the employer. If nano contracts expand the space of life designated as work, they shrink the space that is more easily identifiable as autonomous, where our own caprice reigns. Philosopher Byung-Chul Han has chastised late-stage capitalism as an era where exploitation comes from the self. Everyone carries a work camp inside. On this view, nano contracts threaten the last vestiges of individuality by expanding the fences of our work camp to every second of leisure. I hesitate to offer a general response to such general philosophical concerns. However, it is at least worth noting that for many people, shorter engagements can be life-changing. The gig economy allowed many people who were shunned by traditional labor markets to find a source of income: single parents who could not commit to a regular 9-to-5 job, small business owners who had seasonal lulls, or a recent graduate waiting to land her first job. Nano gigs can do the same for those looking to utilize extra time waiting on the bus or at the doctor's office. In sum, this section presented a potential application of nano contracts to employment. The flexibility they offer is unmatched and the potential is tremendous. But nano work also makes the legal challenges of defining employment and ensuring employee rights harder than ever. If employment collapses to contract, a century of worker rights advocacy will crumble. Nano work also raises some preliminary questions about inequality and the need for demarcation between the space of work and the space of self. Part 7, Nano Accidents. Famously, the Coase theorem holds that the primary reason why we need tort law is transaction costs. Accidents like sparks emitted from passing trains into adjoining fields, create costs and risks. If transaction costs were low, these problems could have been solved by farmers and railways directly, as they would negotiate to the efficient outcome. But, as Coase and the legal scholarship that built on him vividly recognized, ours is not that world. In our world, transaction costs are sufficiently high to prevent such bargains, making it necessary for the law of tort to decide the outcome of accidents. Since then, some of the most important works in tort theory have tried to design rules that would approximate the results of bargains under ideal conditions. As the sophistication and complexity of this literature shows, the task of designing optimal tort rules is challenging, and real-life tort rules likely fall short of this ideal. Nano contracts will not abolish transaction costs, but they can make many of them close to trivial. The four-way stop illustrates a situation where transaction costs impede the efficient allocation of the scarce resource, i.e. right-of-way. As it will be unrealistic for drivers to discuss among themselves, we should get the right-of-way. Traditionally, contracts and torts involve mostly separate realms. While contracts are based on agreement and intent, torts address non-consensual interactions, accidents. The contention here is that nano contracts expand the range of possible consensual agreements. As such, they can turn large spheres of tort law into contract law. To evaluate this contention, let us consider such an instance using a modified version of the scenario suggested by Coase. A train is speeding down the tracks in Iowa. The train's computer reports an imminent electrical load. To avoid damaging the engine, the operator must quickly decide where to emit the sparks: to the right, where there is a cornfield, or to the left, where there is a soybean field. The operator knows that the sparks will cause damage either way. A decision must be made quickly. What should the train operator do? Tort law tries to guide the operator's decision. Under the rules of tort law, the train company will have to pay the field owner for all the harm its sparks caused. The hope is that if the train company will internalize the costs of the accident, it will be motivated to minimize the amount of harm its sparks cause. However, applying tort law in this situation is problematic. Estimating the actual harm caused by the sparks is difficult, and it is likely that the legal system's assessments deviate significantly from the true amount of harm inflicted. This is further complicated because juries may be systematically biased in favor of farmers or trains, so even on average damages will not equal the true harm. Another complication is the effect of time. Currently, the market price for soybeans is much lower than corn, but these prices fluctuate heavily over time, and the operator must decide without a confident sense of what prices are or will be at the time of adjudication. Now suppose the market rates for soybean and corn are at $18 and $758 respectively. And admittedly, this example requires more in the way of suspension of disbelief that the farmers have a nano contract app that can automatically communicate with adjacent conductors. Using a real-time lowest price auction, the conductor can negotiate the accident with the farmers. Neither farmer wants the sparks to cause harm to their crops, but the corn farmer knows that the expected harm to their field is $1,718. Therefore, they bid $5,000 to protect their profits. This allows the corn farmer to come out ahead in the event of an accident. The soybean farmer also sees an opportunity to protect their profits. Since the expected harm to their field is only $754, they can outbid the corn farmer and ask for only $4,000. Even at this reduced rate, the soybean farmer will come out ahead from the accident. Since they will still profit, even if they bid $3,000, they will underbid accordingly. Through this split-second auction process, it is expected that the soybean farmer will win with a bid of $1,017. This will cause the conductor to emit sparks onto the soybean field, causing harm of $754. The soybean farmer comes out $363 ahead, and the more valuable crop is saved. From a social perspective, this is the desirable outcome. We want the inevitable spark discharge to cause minimal harm. The tort system, however, cannot guarantee this outcome because its valuation only occurs after the critical decision has been made. On the other hand, a nano contract can assure that this desirable outcome will follow. It is worth noting that even if the train's computer could consult commodity prices in real time, this outcome would not be guaranteed. Negotiated contracts offer a real advantage over market prices, especially when the owner plans to use their assets in non-traditional ways. Nano contracts also offer a distributional advantage. Under the tort system, the soybean farmer is only entitled to $754, whereas under the nano contract system, the farmer could recover $1,117. If in a given context victims are systematically poorer than tortfeasors, or if tortfeasors can escape judgments, this would be a progressive improvement over the status quo. But even absent such distributional considerations, a working system of nano accidents is better suited to promote society's goals. If accidents were completely subject to contracting, we might have to worry about a different problem. If an accident is inevitable, the farmers act as a monopoly, and they can demand an arbitrarily high price from the train company. Tort law, however, breaks this monopoly on items. If the parties fail to negotiate, the standard rules of tort law apply. This means that the train company will have to pay the farmer for the harm caused, as later assessed by the court. This assures us that the parties will nano-contract only when they deem the outcomes superior to those of protracted litigation with uncertain valuation. A broader question is the dynamic effects of nano-contracts on accidents. If this road is accident-prone, and there are indeed various sites where accidents are common, the soybean farmer will soon make the same realization as Major's father in Catch-22. That is, she can make more money from not growing anything. That way, she can collect $1,117 every time a train emits sparks with little effort. While this seems initially like a perverse outcome, it is actually quite desirable. While the farmer would only abandon their crops if the probability of accidents is sufficiently high. But if accidents in an area are so common, society is well served by having safe areas where sparks can be discharged. On the other side of the ledger, train companies may invest more in anti-spark technology to avoid those regular and predictable payments. This example offers a view on how nano contracts can efficiently minimize harm to victims from accidents and offer compensation for the residual harm that is agreeable to the victim. Such a solution can be extended to many other instances, although caution is required. For reasons that roughly track the discussion on the commodification of cues, we should be wary about the contractualization of accidents that involve bodily harm. In such cases, nano contracts can violate deep moral and social norms. But in many other cases, like those involving trespass or property damage, nano contracts present an opportunity to rethink the alienability of accidents. To generalize, the nano contract instantiates Coase's theorem that parties would negotiate the most efficient outcome in the absence of transaction costs. If accidents cannot be economically prevented, the nano contract would ensure that the harm is minimized. In any event, the optimal result would ensue, but there will be no need for direct state involvement. The parties will negotiate the cost of accidents among themselves. Further, if society cares about the distribution of costs, it can do so via changes to the background tort regime. Conclusion: at this late point, some readers will find themselves in one of two groups. One group will see nothing inevitable about nano contracts, a legal sci-fi that can be easily dismissed out of hand. Another group will have the exact opposite reaction. Nihil sub sol novum, nothing new under the sun. To them, nano contracts amount to no more than a rebranding of gig economy agreements, if not of plain vanilla contracts. The former will find nano contracts fantastic, as they will never materialize. The latter will find them trite, as they have always existed. If there is still room for pleading with these readers, I think both groups have missed out on a key aspect of the article. Consider the wise insight of science fiction author Frederick Pohl. Good science fiction stories should be able to predict not the automobile but the traffic jam. Accordingly, the point here is not to make precise predictions to 2 decimal points about a bright future, or to claim to have reinvented the law of contract. The goal of this article is to think, in a sustained manner, about the culmination of deep existing trends, such as the digitization of transactions, nanonization in the SaaS sphere, minimization of transactional scale, and the tokenization of ownership. Transactions want to be small. What emerges from this investigation, considering the history of contracts, is the insight that scale has a quality of its own. Smaller transaction scale opens new markets, some exciting and liberating, others troublesome and antithetical to our values. Diminishing transactional scale brings with it both the car and the traffic jam. Paying attention to these implications is worth the price of admission. There's plenty of room at the bottom. While I am cautiously optimistic about the future of nanocontracts, there is definitely room for good faith disagreement over whether the net is positive or negative. Clearing up lines effectively, liberating people from the onus and the chase of ownership, and providing new job opportunities can be socially transformative. At the same, we can recognize that there is certainly something unheimlich about a person without possessions, or rather a person with unlimited possession, but none of them hers, and something unsettling about contracting for accidents. Sandel's romantic view of the Q ethics clearly shows that some find it uncanny to let those in a rush or with less patience buy priority from those willing to sell it, and letting people cut in line to the voting booth certainly triggers ethical goosebumps. These differing judgments suggest that there is also plenty of room for scholarly analysis. Which future trajectory do we want to pursue? How might we influence the market? And on a more meta level, should we think about these issues now, or let the market play out and attempt to repair the issues ex post? This article did not attempt to solve all these traffic jams. Rather, it seeks to offer a clear perspective on nano contracts, their structure, and legal implications for lines, property, employment, and torts. Hopefully, these are challenges that would urge us to think about new frameworks the next time we are stuck at a 4-way stop.